The federal government just sent a letter to every single state in this country, all 50, at the same time, and it came with a 30-day deadline. Let that sink in for a second. The Department of Justice, the top law enforcement apparatus of the United States federal government, has issued an emergency directive that lands squarely on the doorstep of every gun owner in America. This isn't a rumor. This isn't a conspiracy theory circulating in the back corners of the internet. This is real. It is happening right now, and the clock is already running. The DOJ sends an emergency letter to all 50 states, and gun owners have 30 days to act, and most of the people who need to hear that haven't heard it yet. That's the problem. That's why we're here. Because while mainstream media is busy chasing whatever political theater is trending today, something genuinely consequential is unfolding. Something that touches the rights, the freedoms, and the daily lives of tens of millions of Americans. If you own a firearm, if you know someone who does, if you believe the Second Amendment means something, stop what you're doing and pay attention. Because what happens in the next 30 days could reshape the legal landscape for gun ownership in this country for decades to come. If this kind of reporting matters to you, if you're tired of being the last to know when something this significant is moving through the system, subscribe right now and hit that notification bell. There are millions of Americans who need to hear this, and the only way this reaches them is if you share it. Don't wait. Do it now. Then stay with me, because we're just getting started. What the DOJ letter actually says, let's talk about the document itself, because the details matter enormously, and the framing of this letter is something every American needs to understand. This isn't a casual policy memo. This isn't a suggestion. The language in this emergency directive from the Department of Justice is precise, it is deliberate, and it is designed to compel action at the state level in a way that creates real legal and administrative consequences if ignored. The DOJ is leveraging its authority under federal law to push states into alignment with a set of regulatory standards and compliance requirements that directly affect how firearms are tracked, registered, transferred, and reported within each state's borders. The letter references existing federal statutes, primarily provisions within the Gun Control Act and the National Firearms Act, and it invokes the DOJ's oversight mandate to essentially tell state attorneys general, state law enforcement agencies, and state legislatures, your current systems are not meeting federal standards, and you have 30 days to demonstrate that you are moving toward compliance. That's the core of it. But here's what makes this particularly alarming. The letter doesn't just address state agencies. It has downstream implications for individual gun owners, because the compliance measures being demanded involve data. They involve records. They involve the kind of registration-adjacent infrastructure that gun rights advocates have been warning about for years. Specifically, the directive pushes states to strengthen their reporting to the National Instant Criminal Background Check System, NISES, and to close what the DOJ describes as critical data gaps that it claims allow prohibited persons to obtain firearms. On the surface, that sounds reasonable. Nobody wants violent criminals buying guns. But when you read the fine print, when you look at how broadly the DOJ is defining those data gaps, you start to see something much more expansive than a simple background check fix. The directive calls for states to report mental health adjudications, domestic violence, restraining orders, drug-related offenses, and a range of civil court actions to federal databases in ways that current state law in many jurisdictions simply doesn't require or even permit. And here's the part that should make every gun owner's ears perk up. The DOJ is explicitly tying federal law enforcement funding to compliance. States that do not demonstrate good faith progress within the 30-day window risk having their federal grant allocations reviewed minus, which is bureaucratic language for fall in line or lose money. This is how federal overreach works in 2026. It doesn't always come with jackboots and warrants. Sometimes it comes with a politely worded emergency letter and a financial gun to your head. The mechanism is different, the coercion is identical, and the implications for your rights as a gun owner are just as serious. What this letter signals is a federal government that is not waiting for Congress to act. It is not waiting for new legislation. It is using existing regulatory authority to reshape the landscape of gun ownership. Through administrative pressure, state by state, database by database, deadline by deadline, that is not how a government that respects constitutional rights operates. That is how a government that has already decided the outcome operates and is simply engineering the path to get there. The 30-day deadline, what happens if you don't act? 30 days. In the context of government action, that is an extraordinarily compressed timeline. Think about what it takes for a state legislature to convene, debate, draft, and pass new compliance measures. Think about what it takes for a state law enforcement agency to audit its current reporting infrastructure, identify deficiencies, and implement fixes. 30 days isn't a reasonable deadline for systemic change. It's a pressure tactic. It's designed to create panic, to force rushed decisions, and to ensure that states are reacting rather than deliberating. That's not governance. That's coercion dressed in official letterhead. But let's be clear about what the consequences actually look like, because this is where it gets personal for gun owners. When states rush to comply with federal directives like this one, they don't always do it carefully. They don't always do it with your rights at the forefront of their minds. They do it to protect their funding, to avoid federal scrutiny, and to check a box. And in that process of rapid compliance, individual gun owners can find themselves caught in systems they never consented to, flagged in databases they didn't know they were in, subject to delays, denials, and investigations that stem not from anything they did wrong, but from administrative data that was hastily reported, incorrectly categorized, or simply misapplied. This has happened before. After previous federal pushes to expand NICS reporting, there were documented cases of veterans being flagged as prohibited persons because VA records describing mental health, treatment, not adjudications, not court orders, just treatment notes, were reported to federal databases. Law-abiding Americans who serve this country found themselves unable to purchase firearms because of bureaucratic overreach. In a compliance rush, that is the real-world consequence of a 30-day deadline. That is what happens when speed matters more than accuracy, when federal pressure overrides individual rights protection. And what happens to the states themselves if they don't comply? The DOJ's letter makes it clear: federal funding is on the table. We're talking about Byrne Justice Assistance Grants, Violence Against Women Act funding, and other streams of federal money that state and local law enforcement agencies depend on for day-to-day operations. That funding covers everything from body cameras to community policing programs to victim services. The DOJ is essentially holding essential public safety resources hostage to force compliance with a regulatory agenda that bypassed the legislative process entirely. For individual gun owners, the message is this: whether your state complies or resists, you are not a passive bystander in this process. If your state complies quickly and sloppily, your data, your records, your rights could be affected. If your state resists, you may find yourself in the middle of a federal-state legal showdown with real consequences for how firearms are legally treated within your borders. Either way, inaction on your part is not an option. The 30-day clock is running, and it's running whether you're paying attention or not. You need to know where your state stands, what your state is doing, and what you personally need to do to protect yourself legally in this environment. The constitutional battleground. The Second Amendment is 7 words that have been debated, litigated, stretched, and weaponized for generations. The right of the people to keep and bear arms, 7 words. And yet here we are in 2026, still fighting about what they mean, not in a vacuum, not in a philosophy seminar, but in real courtrooms with real consequences for real Americans. Because the DOJ's emergency letter doesn't exist in a legal vacuum either. It lands on top of a constitutional landscape that has been fundamentally reshaped by Supreme Court rulings, most significantly the Byrne decision, that established a historical tradition test for gun regulations. And that changes everything about how this directive should be scrutinized. Under the Byrne framework, the federal government cannot simply assert that a firearms regulation is reasonable or serves a compelling interest. It must demonstrate that the regulation is consistent with the historical tradition of firearms. Regulation in America that is a significantly higher and more specific bar. And when you apply that standard to what the DOJ is pushing for in this emergency letter, mandatory reporting of mental health records, expanded civil court data, broader NISC submissions, you start to ask the question, where is the historical analog? Where is the founding era precedent for a federal government maintaining a national database of citizens' mental health history as a condition for exercising a constitutional right? Legal scholars on both sides of this debate are watching this closely. Gun rights organizations, including the Second Amendment Foundation, Gun Owners of America, and the NRA's legal arm, have already signaled that litigation is coming. They are arguing that the DOJ's directive, to the extent it pressures states into reporting mechanisms that effectively create registration-adjacent databases, runs afoul of the Bruin standard and potentially violates the firearms owners. Protection Act of 1986, which explicitly prohibits the federal government from establishing a national firearms registry. That's not a fringe legal argument. That's a mainstream constitutional challenge grounded in real statutory and case law. And given the current composition of the federal judiciary, shaped by years of appointments that have trended toward textualist and originalist interpretations, these challenges have real teeth, cases are going to be filed, injunctions are going to be sought, and depending on how quickly the courts move, some of those legal fights could intersect directly with this 30-day compliance window. What this means for gun owners is that the constitutional battle is not lost, but it is active, it is urgent, and it requires your engagement. Every gun owner who contacts their state representative, every gun owner who supports legal defense organizations, every gun owner who shows up at a city council meeting or a state legislative hearing, they are participants in this constitutional fight. The courts don't operate in isolation. They respond to the political and social environment around them. And right now, that environment needs to send a clear signal that Americans are not going to watch their constitutional rights get quietly eroded by administrative pressure campaigns disguised as public safety measures. Who's behind this push and why now? Nothing in Washington happens without political calculation. Nothing from the Department of Justice, especially something this sweeping, this urgent, this deliberately timed, happens without a reason that extends beyond the stated rationale. So let's ask the question that the mainstream press is too timid or too captured to ask: why now? Why in 2026? Why this mechanism, this deadline, this particular configuration of pressure? The timing is not accidental. We are in a moment of significant political flux in this country. The 2026 midterm elections are on the horizon. The political coalition that controls the executive branch has made gun control a signature issue, and it has repeatedly run into the wall of congressional arithmetic. The votes simply aren't there for sweeping gun legislation through a divided or resistant Congress. So what do you do when you can't get what you want through the legislative process? You go around it. You use the regulatory and administrative apparatus of the executive branch to accomplish through pressure and procedure what you couldn't accomplish through law. This is not a new playbook. It has been used on environmental regulation, on immigration enforcement, on healthcare policy. The administrative state is a powerful instrument, and the people who understand how to use it have become extraordinarily sophisticated at deploying it in ways that achieve major policy outcomes while technically remaining within the boundaries of existing statutory authority. The DOJ's emergency letter is a masterclass in that approach. It doesn't create new law. It reinterprets existing law. It doesn't mandate registration. It expands reporting. It doesn't ban guns. It restricts the conditions under which guns can be legally obtained and maintained by certain categories of people, and it defines those categories expansively enough that millions of Americans could be affected. There are also financial interests at play here that rarely get discussed: the expansion of background check systems, the development of new reporting infrastructure, the integration of state and federal databases. All of that requires technology, it requires contracts, it requires vendors, and the companies that build and maintain those systems have significant financial incentives to see those systems expanded. When you follow the lobbying dollars, when you look at who is advocating for these compliance frameworks at the federal level, you will find technology companies and data management firms that stand to profit enormously from the infrastructure build-out that this directive would require. That doesn't mean the stated public safety goals are entirely insincere, but it does mean that the people driving this agenda have multiple motivations, and protecting the public is not necessarily the dominant one. Power, money, and political advantage are always in the room, always. And any honest accounting of why this emergency letter went out to all 50 states right now has to include all of those forces, not just the sanitized version offered in the official press statement. If you've made it this far, you already know the story isn't getting the coverage it deserves anywhere else. Subscribe right now, share this with every gun owner you know, and drop a comment below telling me what state you're in and how your state is responding. That information matters. Your voice matters. And this channel exists because people like you demand better than the filtered, softened, agenda-driven coverage you get everywhere else. Stay with me. How states are responding, the divide. America in 2026 is not one country in any meaningful political sense when it comes to gun rights. It is a patchwork of jurisdictions with radically different legal cultures, political priorities, and relationships with federal authority, and the DOJ's emergency letter has made that divide visible in real time. The responses from state attorneys general and governors have ranged from full-throated defiance to quiet, rapid compliance. And everything in between, and where your state lands on that spectrum, has direct, practical consequences for you as a gun owner. On one end of the spectrum, you have states like Texas, Florida, Montana, and Wyoming. States where the political identity is deeply intertwined with gun rights and where resistance to federal overreach is not just a political position, but a pre-governing philosophy. Attorneys general in several of these states have already issued public statements challenging the legal basis of the DOJ directive. Texas has been particularly aggressive with its AG signaling potential litigation and invoking state sovereignty arguments that echo the legal battles over immigration enforcement from previous years. Montana went further, with state legislators introducing emergency measures to prohibit state agencies from complying with federal directives that they believe conflict with state law protections for gun owners. On the other end, you have states like California, New York, Illinois, and Colorado, states that have been expanding their own gun restrictions and that see the DOJ directive not as an overreach, but as a floor they've already exceeded. For these states, federal compliance isn't a burden. It's an opportunity to claim federal validation for regulatory frameworks they've already built. Their attorneys general are welcoming the directive, some even publicly calling on the DOJ to go further, to be more aggressive, to close more loopholes. They're not just complying, they're cheerleading. And then there's the messy middle. States like Pennsylvania, Michigan, Wisconsin, Georgia, and Arizona, politically divided states with split legislatures or recent power shifts, where the response is more complicated. In these states, the DOJ directive lands in a political environment where the governor and the legislature may not agree, where law enforcement agencies have their own institutional interests, and where the gun-owning population is large and politically engaged. These are the states that are going to be most volatile in the next 30 days. These are the states where the outcome is genuinely uncertain and where political pressure from constituents could actually make a difference. The divide is also playing out at the county and local level in ways that the national press is largely ignoring. Second Amendment sanctuary resolutions, where counties and municipalities declare they will not enforce gun regulations they consider unconstitutional, have been adopted in hundreds of jurisdictions across the country over the past several years. In the wake of this DOJ directive, that movement is accelerating. County sheriffs in states as varied as Oregon, Virginia, and Illinois are publicly stating they will not enforce compliance measures that they believe violate their constituents' rights. That's not uniformity, that's fragmentation. And fragmentation in law enforcement creates exactly the kind of uneven, unpredictable legal environment that is most dangerous for ordinary Americans who just want to know what the rules are and how to follow them. The bottom line is that where you live is going to determine a great deal of what your experience of this 30-day deadline looks like. That's unacceptable in a country that's supposed to have one constitution. But it is the reality, and you need to know it. What gun owners must do right now. This is the section that matters most, because everything we've covered up to this point, the letter, the deadline, the constitutional fight, the political machinery, the state divide, all of it is context. Important context, essential context. But context doesn't protect your rights, action does. And if you are a gun owner in America right now, there are specific, concrete things you need to do in the next 30 days to protect yourself, your rights, and your legal standing. The first thing you need to do is find out exactly where your state stands, not the version you'll get from a 30-second news segment. The actual current status. Go to your state attorney general's official website. Look for any public statements or press releases about the DOJ directive. Check whether your governor has made any public comments. Look at whether your state legislature has any emergency sessions scheduled or any relevant bills in committee. This is your baseline. You need to know the terrain you're operating in before you can navigate it effectively. The second thing you need to do is contact your state representatives, your state senator and your state house member. Not a form email, not a social media post, a direct communication, a phone call to their office, a formal written letter, or an in-person appearance at a constituent meeting or town hall. Tell them your name, your district, and your position. Tell them you are watching how they respond to this directive. Tell them that your vote in the next election will be influenced by whether they stood up for your constitutional rights or capitulated to federal pressure. Politicians respond to political pressure. That is the fundamental mechanism of democratic accountability. Use it. The third thing you need to do is connect with legal defense organizations. If you are a gun owner and you are not a member of at least one organization that provides legal defense for Second Amendment rights, you are operating without a safety net in an increasingly hostile legal environment. The Second Amendment Foundation, Gun Owners of America, the Firearms Policy Coalition, and your state-level equivalents all provide legal resources, litigation support, and educational materials that can make a real difference in how you navigate situations where your rights are threatened. Membership fees are modest. The protection they provide is not. The fourth thing, and this may sound basic, but it is critical right now, is to make sure your own house is in order legally. Know exactly what firearms you own and how they were legally acquired. Make sure you have documentation for all purchases made through licensed dealers. If you have any legal matters in your background, civil or criminal, that could affect your status as a lawful gun owner, under expanded reporting criteria, talk to a firearms attorney now, before those reporting systems are updated, before the data changes, before a problem becomes an emergency. An ounce of legal preparation right now is worth a year of reactive damage control later. The fifth thing is to stay informed and stay connected. The situation is moving fast. The legal landscape is shifting. State responses are evolving. Court filings are being prepared. New information is emerging. You cannot afford to check out, to assume someone else is handling this, to decide you'll look into it next week. The 30-day clock does not respect your schedule. It runs whether you're watching or not. Find the sources that are actually covering this, not the ones that are dismissing it, not the ones that are spinning it, but the ones that are doing the hard work of tracking what's actually happening on the ground in each state and at the federal level. And here's the broader point, the one that transcends this specific directive, this specific deadline, this specific political moment. The price of constitutional rights in America has always been the active, ongoing, engaged participation of the people those rights belong to. The Second Amendment did not survive 2 centuries of political opposition by accident. It survived because generations of Americans treated it as something worth defending, not just in principle, but in practice, not just in rhetoric, but in courts, in legislatures, in elections, and in the daily choices of millions of citizens who refuse to let it be quietly erased. What the DOJ is attempting right now, through an emergency letter, through a 30-day deadline, through financial coercion of state governments, is the latest chapter in a very long story. And like every chapter before it, the outcome depends on you, on whether you show up, on whether you speak up, on whether you decide that this matters enough to act, or whether you decide to wait and see and hope someone else takes care of it. No one else is going to take care of it. It has to be you. It has to be now. The DOJ sent an emergency letter to all 50 states. Gun owners have 30 days to act. That clock started before most people even knew this was happening. Now, the question is what you do with that knowledge. The question is whether you become one of the Americans who looked at this moment clearly, understood what was at stake, and chose to engage, or whether you become one of the millions who found out too late, after the deadline passed, after the databases were updated, after the legal landscape shifted beneath their feet. History doesn't remember the people who watched. It remembers the people who acted. If this reporting gave you something, if it informed you, challenged you, or prepared you for what's coming, then do 3 things right now. Subscribe to this channel so you don't miss a single update as this situation develops. Share this with every gun owner you know, because the people who need to hear this most are the ones who aren't hearing it anywhere else. And drop a comment below. Tell me your state. Tell me what you're seeing on the ground. Tell me what questions you still have. This conversation is bigger than any one video, and your voice is part of it. Stay sharp, stay engaged, and don't let anyone take what the Constitution guarantees you, not without a fight.